Hello, BA 600 class. My name is Ashish IRP and I represent Group 9. I'm going to speak about employer relationship, specifically employer rights and employee rights and responsibilities. But before going into my slides and the external resources, I would like to present my perspective regarding the employer relationship. So, if you see, there are two fundamental things in any of the organization. For example, like there's an employee and there's an employer. Employer is the one who sets the strategies, the goals, the missions, and also make sure that the organization is moving to the correct path in the parallel of those strategies. And uh, and the employee is the person who carries out those tasks, and they are the person who works at the ground level and make sure to execute those strategies. So what I think is there should be a beautiful coordination, a mutual understanding, and an excellent relationship between an employee and employer. Though an employee and employer both have some rights and responsibilities, also they have many obligations to follow. So let's discuss about those. Going inside the presentation. Well, employers and employees have a responsibilities to each other. They should also expect their rights to be upheld. These rights and responsibilities relate to areas such as health and safety, the provision of terms and conditions of employment, equal opportunities, and the right to be paid a minimum wage. Employers are expected to abide by a range of requirements governing such aspects of providing safe machinery and equipment, carrying out regular health and safety checks, ensuring the training of employees in health and safety issues, and carrying out assessment to assess the dangers of particular work activities. Employees are expected to receive the terms and conditions of their work, setting out when their work commences, what their main duties are, who they are accountable to, rates of pay, and other entitlements. When talking about the rights and responsibilities, rights are powers, privileges, or interests granted by law, nature, or tradition. Mostly, rights generally do not exist in the abstract. Statutory rights are the result of specific laws and statutes passed by federal, state, or local government. Rights are offset by responsibilities, which are obligations to perform certain tasks and duties. Well, if you see the employment contracts, it is a formal agreement that outlines the details of the employment. Depending on the organization and individuals involved, employment agreements may contain a number of provisions. It may also include non-compete agreements which prohibit individuals who leave an organization from working within an employer in the same line of business for a specified period of time. There also exists an implied contract, which is an unwritten contract between individuals and their employees, which affects the employment relationship. Well, what exactly are the rights affecting the employment relationship? So, to consider those, the first one is employment at will. Uh, it is a common law doctrine stating that employers have right to hire, fire, demote, or promote whomever they choose, unless there is a law or a contract to the contrary. Conversely speaking, employees can quit whenever they want and go to another job under the same terms. The second one is wrongful discharge. Employees who run afoul of EAW restrictions, that is, employer at will restrictions, may be guilty of wrongful discharge, which is termination of an individual's employment for reasons that are illegal or improper. Well, employers should take several precautions to reduce wrongful discharge liabilities. Having a well-written employee handbook, training managers, and maintaining adequate documentation are the keys. The third one is just cause. Well, just cause is a reasonable justification for taking employment-related action. The need for a good reason for disciplinary actions such as dismissal usually can be found in union contracts but not in at-will situations. Due process. It is a requirement that the employer has a fair process to determine if there has been employee wrongdoing and that employee have an opportunity to explain and defend his or her actions. Privacy rights. Talking about the privacy rights, what exactly are the privacy rights? As a result of concerns about protecting individual rights, privacy rights in the United States, the Privacy Act of 1974 was passed. It includes provisions affecting HR record keeping systems. The first one is employee medical records. Record keeping and retention practices have been affected by the Americans with Disabilities Act, that is ADA, as interpreted by attorneys and HR practitioners. The Act requires that all medical related information be maintained separately from all other confidential files. Additionally, it is important that specific access restrictions and security procedures for employee records to be established. These restrictions and procedures are designed to protect the privacy of employees and to protect employers from potentially liability for improper disclosure of personal information. For instance, security breaches can occur through employer records regarding an employee's social security data, home address, and family details, especially by electronic means. Electronic records. Employers should have established electronic record policies to ensure legal compliance and to avoid violating individuals' personal rights. So let's come to employees' free speech rights. The right of individuals to freedom of speech is protected by the US Constitution. However, that freedom is not an unrestricted one in the workplace. Three areas in which employees' freedom of speech has collided with employees' restrictions are controversial views, whistleblowing, and one of the internet and other technology. Questions of free speech arise over the right of employees to advocate controversial viewpoints at work. Employers must follow due process procedures and demonstrate that disciplinary actions taken against employees can be justified by job related reasons. The first one is whistleblowers. To talk about whistleblowers, what are the whistleblowers? Individuals who report real or perceived wrongs committed by their employers are called whistleblowers. It is more likely to happen in public environment than in private employment because most civil service systems follow rules protecting whistleblowers. So there are less chances of whistleblowers to occur in private sector. Well, here's the point: technology and employer or employee issues. The growth of technology used by employers and employees is constantly creating new issues to be addressed. Such technology, such as Twitter, social networking, and blogs, require attention by employers. So, employers have a right to monitor what is said and transmitted through their network and voicemail systems, despite employees' concerns about free speech. So, that's all from my side regarding rights and responsibilities of employers and employees. Thank you.